Yes, good evening to everybody and welcome to
Yes, my colleague.
Of all advanced private international law. And if your colleagues wants to join, let them join it. So we don't mind. If one person also there, I will continue my class. That is my spirit. So I could see that you could see my screen also. See my screen? Could you see my screen?
I can. Yes.
Can you read this?
Your screen, I can view it.
Can you read what I highlighted there?
Can you maximize, please?
See here, this is the template. There is no maximum, we can make it out. So I tried my level best, but I could not make it out. But you can enlarge your in the smartphone and make it a landscape, and you could see it very clearly. But anyway, it doesn't matter. So here, that what I want to say, a leading case is there, that is Bell versus Kennedy. I repeat, a leading case is there, Bell versus Kennedy. So here Bell was born in Scotland. Bell was born in Jamaica of Scottish parents. Where is the Bell has born? Yes? Where the Bell has born? Please unmute and say. Suppose if you don't know, say, pass on.
Can you repeat it, sir?
It is clearly on the screen. Bell was born in Jamaica of Scottish parents.
Yes.
So, his domicile of origin being Jamaica. Whose domicile of origin is Jamaica? Bell. Isn't it? Say yes. So, if you see the Bell born in Jamaica, does it mean he is a domicile of Jamaica? Yes.
Jamaica is his domicile of origin.
How could you say that merely born in the Jamaica, but the parents are Scottish parents? The parents are Scottish parents. That means parents' domicile may be the Scotland. So now let us see that how it will make takes the turn. So his domicile of origin being a Jamaica, he was educated in Scotland, very good, but returned to Jamaica and attaining the majority. About 14 years later, he returned to Scotland again without any intention of returning to Scotland. When his wife died, after her death, he succeeded in locating a suitable estate which is purchased, and it was admitted that at the time of the trial, he had acquired a Scottish domicile. So, at the admit of the trial that it is acquired that he is acquired the Scottish domicile, but the question in the case was whether he was a domicile in Scotland at the time of his wife's death. That is the question. So it was held Bell was domiciled in Jamaica at the time of his wife's death, no doubt. Although he left Jamaica for good and been residing in the Scotland looking for a suitable place to settle down. Evidence showed that at the time of his death, wife's death, his mind was vacillating with regard to the future home. Where should we want to make a future home? So it was held, therefore, since he had not at the time acquired the Scottish domicile of choice, he retained the Jamaican domicile of origin. So overall, the intention is he doesn't want to continue there in the Scottish, then automatically his domicile of origin will be Jamaica. So Jamaican domicile of origin. As at the present, one important point of distinction between the domicile of origin and the domicile of choice is that farmer is never lost and is in a position to revive where the later cannot revive, and is lost forever the moment a person leaves the country of his choice, amino non reverendi. He returned back to it. So what is permanent here? Permanent here is domicile of origin. Then what is the next domicile of choice? If the domicile of choice is in doldrum, we cannot say that whether a domicile of choice is acquired or not. At that instance, what will be the domicile of him? Yes. What will be this domicile of him? If you know it, you tell me. If you don't know it, you say pass on. I will give you the answer.
Both network is not sufficient.
See, if the domicile of choice is in doldrum, it cannot be proved over there. At that instance, what will be the domicile of that person? Yes?
We've been in Rwanda.
Rwanda. Why Rwanda has come here? See, when the domicile of choice is in doldrum, it cannot be proved over there. Then what will be there? Domicile? Domicile of origin will be revived. What will be the domicile? Domicile of origin will be Sema? Revived. So welcome to Dorcas, Macminan Lema, Raymond Cosmas. You are welcome to my class, and today is the full quorum. Are you followed? Did you get my point?
Thank you.
Did you get my point? Say yes or no.
Yes, sir.
So, whenever the domicile of a choice is difficult to prove or it is in doldrum, we cannot make it out. At that instance, the person domicile is domicile of origin will be revived, because no person in this world without a domicile, like no person in this world without the name. And in the digital world, now no person in this world without the email ID. Am I right? Am I right? Say yes, sir.
Yes, sir.
I appreciate. See, the purpose of asking me is, you are with me and I am with you. That's my intention. So now let us go to the next point, comparison between the domicile and nationality. So now you tell me, how could you determine yourself, you are the nationality of so-and-so country? Anyone? Yes? If you know it, you tell me. If you don't know it, please don't waste the time. You say pass on. I will give you the answer.
Pass.
Pass on. P-A-S-S pass. space on, pass on. Okay, now I'll do that. See, for instance, you take my case. Am I a nationality of Tanzania?
No, no, sir.
Then what is my nationality?
Indian.
Indian. Why Indian? Because I was domicile of origin. The reason is my parents are domicile in India. So my nationality is
Indian.
India. Now, suppose if I want to change the nationality, you tell me. Suppose I acquired the domicile of choice in Tanzania. Then I got the bank balance, I had the house, I constructed the things, my children are studying, my wife is working, I am also working, I have the bank balance, I have the member of the place, and I acquired the citizen of Tanzania. Then automatically now my domicile, my nationality is
Tanzania.
Tanzanian nationality. So a nationality can be changed because of domicile of choice plus taking the citizenship, taking the voter list, and everything, the nationality will be changed. When you come to the matter of the domicile of origin will holds good. But when you come to the nationality, domicile of origin plus the father domicile, where it will be there, then it will be represented as the nationality over there. Let us see that how it can be made it over there. It is a common in a private international law practice for the court to face a same setbacks in determination of whether domicile or nationality is determining factor as to the question of which the law should be applied. So, nationality represents person political status. I repeat, nationality represents person political status by virtue of which he owes allegiance to some particular country. Because I born in India, my parents are born in India, then automatically my nationality is India. So, domicile indicate his civil status. So what the domicile indicates? It is a civil status and a country in which a person has established his permanent home. So if I have intention to stay permanently in a particular place, at that instance, even though it is not my domicile of origin, then acquired by the domicile of choice. At that instance, when I acquire the domicile of choice, then naturally, if I have the change my citizenship also to get the voter right, at that time my nationality will be changed. So courts have, however, applied either of them to reach a just decision and picking which would be among the nationality or and domicile. They have been ensuring not only the justice is done, but seen to be done. That is it is the equity principle. What is that? A justice is done, okay, no doubt, but it seems to be done. It looks to be done. That is a very important factor. That is to say, whenever courts selected a determinant among the two, that is a domicile and nationality, court gave reason as to why one is entertained and not the other. The reason are merits and demerits of those determinant factors. So in some places, we will consider domicile only, but in some places, we consider the nationality. Let us see the merits of the domicile. Can anyone unmute and read the first tick mark? What is that? Yes.
Merits of the first one.
Go ahead.
Domicile is the only fitting determinant in nations formed by union of states or federal form of nations such as United Kingdom, Australia, and the United States of America.
So when you say the domicile, we cannot say domicile of Mwanza. What do you say?
Domicile of Tanzania.
Because it will be represented by the states or union or federal form of nations. So that is the first. Yes, next participant, read the second one. Haraka.
It is more natural.
Proceed. Yes.
Abandon laws of that country, as natural justice requires one to judge by laws which bind him. Domicile is appropriate.
So now it is more natural and appropriate how a determinant of the personal law. If you want to see a person should be taxed. If you want to see a person's matrimonial property will be distributed. At that instance, domicile is useful in the sense that if a person has decided to abandon his country of origin, he has also automatically abandoned the law of that country. So a natural justice requires one to judge by the law which binds him. Domicile is appropriate. See, once if you abandoned one country, nation, that means if you abandoned the choice of that origin, naturally you might have chosen the choice of domicile of another country. So at any given point of time, there should be a domicile of a person, either of origin or, yes, either of origin or
of choice.
Domicile of choice. I appreciate. So third one, domicile only practical test in certain political unit such as Tanzania, India, UK, USA, where a person same nationality, a different legal system. But when you belong to a Tanzania, naturally the domicile of Tanzania, then we say you are not a domicile of you are not a domicile of Kenya. You are not a domicile of nationality of Kenya. Because when you domicile of Tanzania, automatically you will be the nationality of
Tanzania.
Now let us see the demerits. What are the demerits of domicile? So irrational result may result. Long residence is not equivalent to the domicile if accompanied by the contemplation of some certain event, the occurrence of which will cause the termination of residence. Sometimes, as I told you in the Ramsey versus Liverpool, Infantry Limited, see, he lived in the Liverpool for 36 years because, tell me, because if you don't know, you say pass on. I will give the answer.
He was not having indefinite leave.
He doesn't have the chakula to eat. He's a parasite. So he relied on the father, brother, sister, mother, those who are in the Liverpool. But he is a domicile of origin of Scotland. Because he doesn't have any other thing to live there except for the food, he is getting free because he's a parasite. Do you know what is meant by parasite? Living on
someone who is living on another.
Yes, I appreciate. So naturally, even though he stayed for the 36 years also, but still at the time of the death, the will say he is not a domicile of Liverpool, that is England, but is a domicile of domicile of? Oh, you are, see, I repeated this and I told in yesterday class also. Scotland.
Scotland.
Yes. So now let us see the second point. The legal or the social uncertainties may arise and cause one's permanent home to be determined.
I'm sorry, I did not get the first point clearly.
Which first point? There is a irrational.
The result.
Is it? Is it the irrational?
Yes.
May ensure. If you stay in a permanent place for a long time, but without any contemplation of intention to stay over there, at that instance, even though you stay for a long time, it doesn't mean that you acquire the domicile of choice. That is the first point.
Understood.
The second point is legal or social uncertainty may arise and cause one's permanent home to be terminated. So sometimes if untoward incidents happen, then permanent home would be terminated and expires of living permits and outbreaks a civil war. A civil war there, untoward incidents happen, an act and a good example which may cause termination of domicile. Suppose if your domicile of another country, if there is a war between that country and where you are residing in that country, at that instance, naturally you will forego the domicile of that another country because another country is enemy to your country where you are staying here. So at that time, in the war time, you lose your domicile, a permanent residence. So that is the second point. Third, domicile is hardly ascertainable. A person should state his intention in order to ascertain the domicile. As I told you already that he should have an intention. How the intention will be known? Unless until he is having a citizenship of that country and he is having the bank balance of that country and he is having the job in that country and where his children are admitted in the schools. All these incidents make it out. Yes, he is having the permanent intention to stay in that country. Even though his domicile of origin may be the different, but here he acquired the domicile of choice. So here I want to say practically intention of the litigant is exclusive. And this makes it hard to identify the clarity. It is for the court to decide after going through the given facts. So now the court will interfere on the given facts to determine whether this fellow domicile is which domicile, either domicile of choice or domicile of origin. Now how the court has come to the conclusion in the Ramsey versus Liverpool Infantry? Tell me. How the court come to the conclusion that Ramsey domicile is? Yes. Yes.
Because he had no intention of staying at Liverpool, so he did not acquire the domicile.
There is none. Then how the court has come to the conclusion of at the time of the Ramsey death, what was his domicile?
Scotland.
Scotland, appreciate. Because Scotland is the domicile of origin of Ramsey. So court will go through the facts of the case and come to the conclusion. And they will decide in that manner. Now let us see the merits of the nationality. It is the easily ascertainable. There are opaque proof of nationality which are understood without application of the complex legal technicality. So if you want to see a person nationality, Is it difficult to find it out? Yes. Is it difficult to find it out
Sorry.
what's nationality?
Sorry, network problems. Could you repeat the question first?
Suppose if you want to say a Persian nationality, is it difficult to identify that he belongs to the nationality of that country? How do you determine?
No, it's not difficult.
It is not difficult to identify because suppose my case, how could you say that I am nationality of India?
Language.
I born in India, my parents are born in India, and I got the domicile of origin in India, and it is very easily we can say that I am the nationality of India. So how would I determine yourself as the nationality of Tanzania? I can say now you are the nationality of the Tanzania, provided your parents are born over here and stay over here and you born in Tanzania. So it is not difficult to identify what is your nationality, provided if you know the domicile of origin. So nationality depends apart from naturalization. Of course, suppose if you changed yourself and naturalized yourself to Tanzania, acquired the domicile of Tanzania, took the citizenship of the Tanzania, automatically the nationality will be changed and the nationality of Tanzania maybe. So on the place of birth or on a parentage. So where do you belong? The birth or a parentage, where the parents will belong. And of course, there's a registration also. I mean, what registration? Birth registration. The code therefore meet the advantage of nationality by of easily ascertainability. So it is very easy to make it out the nationality of a person. So a nationality is more stable than domicile. This is because nationality cannot change without the formal consent of the state of a new nationality. So it cannot change it unless until the other country accepts the citizenship of a person. And this makes a nationality stable determinant. So if the domicile of choice will not be acquired over there, if there is any objection by the Tanzanian government, at that instance, I cannot get the nationality of Tanzania because I could not fulfill certain conditions and my stability would be there. I would be still belongs to the Indian nationality. So nationality is a stable factor unless until something will be changed permanently. So let us see the demerits of nationality. Applying the test of nationality may point to a country in which a litigant has lost all connections or to which perhaps he has never been connected. So now question comes, we don't know where he belongs because his connections are lost over there. At the time, it is very difficult to him which is the nationality of that person. Because, of course, it not be that much difficult factor when you come to the matter of the domicile. Because whatever is the domicile, and if you acquire the new domicile, automatically you will use the new domicile, your domicile of choice. If the domicile of choice is in doldrum, it cannot be made over there, then domicile of origin will be automatically revived. So here demerits is nationality can be changed provided the domicile will be changed. So this is for an example, Tanzania male domiciled in the UK. Tanzania male domiciled in the UK for the whole of his life. He has technically lost connection and his children, if any who are below the 18 years, the age are regarded as Tanzanians until they reject their Tanzanian citizenship. And these children are perhaps have no connection with the Tanzania, applying the Tanzania law basing on nationality on this subject is unjust. So sometimes it's very difficult to find it out, the connection with the country. At that instance, we will feel where the parents stay, where the parents are born, that will be the domicile of the children. Even though there is no connection between the children and father, because father is a Tanzanian, but domiciled in the UK. So sometimes the demerits would be their nationality, so it is difficult to find it, and unjust also when the matter comes in such a way. So now the second point, nationality is erroneous. Sometimes in the eye of English law, no person can be without domicile. That is the obvious factor. No person can have more than one domicile. That is also obvious factor. At the same time, on the other hand, a person may be a stateless or may simultaneously be a citizen of two or more countries. Now the question comes, how could be a person take the citizenship of the two countries? Can the Tanzania will allow such a two citizenship? Give me the answer.
No.
No.
But if you see the Egypt, it will allow. Suppose if a person is settled there, domicile in the USA, and he is the permanent residence, but the person is born in Egypt, at that instance, the government allow them, he can be a citizen of Egypt and he can also be a citizen of USA. So whenever he wants to go, he is having the two passports. And I believe that he doesn't need the visa because he is of the citizenship of the two countries and he is having the passport of two countries.
Both countries.
Two countries. Number one, where he was born. Number two, where he got the domicile of choice. So that is the point. Nationality is erroneous sometimes in the eye of English law. No person can be just, we read it, citizen of the two more countries at the time. When a person is having the two more countries, how could you determine his nationality? You tell me. Yes. It's a difficult task to determine the nationality of him. Because whenever he is there in USA, he is a citizenship and nationality of USA. But whenever he is there in Egypt, he is a citizenship and the nationality of Egypt. So it is difficult to make it out when the two citizenships are there. So the last point is nationality is not useful in political setting as a federal, state and union. In the nationality, we cannot consider, especially in the state level, for there are some circumstances in which there is no law applicable throughout the nation, rather law according to the state. So the nationality comes in very few places where we can consider it. But domicile comes in all aspects. So finally, private international law is a dispute, is a discipline. Other topics of law which seeks to justice in its determination, advocating the... Yes, please, ask the question.
Yeah, I'm sorry, I could not actually hear anything concerning on the last point. Nationality is not useful.
I will elaborate. We generally don't consider nationality because it comes only in little factor, that is national patria, the patriotism of the nationality. The connecting factor is very rarely used and we can ignore also. But domicile of origin is a very important factor. Any domicile. So nationality doesn't have an importance when you compare with the domicile. That is actually the point. Is it clear? That is actually the point where it is highlighted there. Is it clear?
It is clear. It
Now
is clear.
let us see the commercial domicile or quasi-domicile. No, we did not have because it is a headache. Commercial domicile and quasi-domicile, that is make another headache to us because this is enough what we studied over there. In our syllabus, I did not see the commercial domicile and the original domicile. Here the commercial domicile means whenever you have the business transaction, at the time you will have such a understanding between the two countries. They will make the domicile of commercial domicile, they will make it. But in general, we don't have in a syllabus. But in India, they made such a distinction also to make it out. So overall, the conclusion, of course, still we have 10 minutes in our hand, but let us see what is the conclusion they made it. The law of domicile in India, or not only India, anywhere in the world, is a crystal clear. What is crystal clear? Can you tell me? What is crystal clear? If you know it, you tell me.
Easily understood.
You can say Pasa.
Person.
No person should
Something straight with no doubt.
means every person have a domicile. That is one crystal clear. And at any given point of time, only one domicile. Is it a crystal clear?
Yes.
That is the clear. Either you take Tanzania, you take India, you take Malaysia, you take anywhere in the world. It is a crystal clear that every person having the domicile, that is domicile of origin. And every person having only one domicile, not two. But every person may have two residences. For instance, take my case. I have the residence permit, going to get it soon. So I'm a resident of Tanzania. But when I go to India, I'm the permanent resident over there. So my residents are how many?
Two.
Two. One is India, one is India, one is Tanzania. So now let us see the next point. The same is important for resolving the conflict of laws in India or in Tanzania or anywhere in the world. There seems to be an ignorance of the concept in two perspectives. Of course, there is an urgent need to spread public awareness. What public awareness in this regard? Because everybody knows no man without a name. Am I right?
Yes, sir.
In the same manner, no man will exist without a domicile. And no man would have the two domicile. But he may have two residences. So now it is there are many decided cases there, both English law and in Tanzanian law also. And we'll see that. And I don't know whether you read that case law or not. Gharib Abdullah versus Kim Langi. I've forgotten the next name. Is case law, very interesting case law. Oh, this has come. But I want to share something. This is my so. See, I want to share something, but it is coming in different way. That is
it reported, Prof?
K. Milinga. And that case law shows that how the law in Tanzania will play an important role over there. I will give the full details of the case law. because still we have only 5 minutes in our hand. And there is a detailed case law is there. I don't want to make it out. Yes, I found it. Could you see now the case law? I shared. I can magnify it. Is it visible?
It is.
Yes.
See, this is the case. Arif Abdullah Juma versus K. Melinga. So the facts of the case law, if you see it, of course, by exactly 10 o'clock it will be closed. But doesn't matter. Up to that extent, I will deal this thing. The appellant, a Tanzanian from Zanzibar, lived in Denmark. On 24th October 1984, he married a respondent, a Tanzanian from the mainland in Denmark. Actually, he is a Zanzibarian. Who? Garib Abdullah Juma. Now, the K. Melinga, she is from the mainland of Tanzania. And they married in Denmark. And Denmark was one of those countries in Europe which practiced, and perhaps still practices, the system of community of property to be married people. So there, the community property will be equally distributed among the married people. That is the law of the Denmark. So in order to avoid the full effect of that system, the appellant decided to enter into the marriage settlement with the respondents 2 days before the marriage. So this Garib Abdullah Juma, so intelligent that before the 2 days before marriage, he wants to make an agreement with the lady K. Melinga. That is, the agreement says like this. At the time, he owned a flat in Copenhagen and he wanted to exclude it from a matrimonial property. And this is very much made clear in the agreement before the 2 days before marriage. According to the appellant, he had other properties before marriage. So that he is having another property also. And the marriage settlement, those property outside the Denmark, and those were housed in, of course, in Zanzibar. They do have some property in Zanzibar. Of course, the name also here given over there. And that is inherited by his mother, who? Garib Abdullah mother. And he had another house also in Zanzibar, of course, name also given over there, and which he said he had built the roof stage. So now what I want to say is, he is having the houses in Zanzibar, and there is a pre-agreement between them in the Denmark. So K. Melinga, of course, after the 14 years later, they are separated. So K. Melinga filed a case in the High Court of Zanzibar, stating that the agreement which will be made should be applicable over there in Zanzibar, and the property which he got it in Zanzibar should be given equally. The High Court of Zanzibar, they said, yes, the agreement made in the Denmark should be applied over here, and the property which he is having at the Zanzibar, it should be equally distributed. Then Garib Abdullah approached to the Court of Appeal in Zanzibar. Then Court of Appeal clearly made it clear. The agreement which made before the marriage in Denmark could not be applied in Zanzibar. Number two, whatever the property is there in Zanzibar would be, it will be surveyed and determined how much the amount will be there. Depending upon that factor, okay, some portion of it may be given. But overall, they said like that, but the appeal which made by the K. Melinga, of course, it is an appeal which made by the Garib Abdullah in the Court of Appeal in Zanzibar, and he won it. And the decision which is given by the High Court of Zanzibar is no more valid. So that was the decision which is given in the Gharib Abdullah. Of course, we do have the full case law and you can study it, and it is available in the net also. And if you want, I can post to you also the full case law so that you could understand how the division would be there and how the applicable law would be there, and you could understand it, and which law could be applied and which law could not be applied, and you could know it. So, and I will have still 1 or 2 minutes. At any time it will be stopped. Meanwhile, if you want to ask any question, you can ask me. Yes. Meanwhile, if you want to ask any question, you can ask me. Yes. Still 5 minutes are there. Participants, are you with me? Participants?
Yes.
Why you are not giving reply to
Yeah.
me?
Some network problems, Prof, but I've understood.
Okay, one is having net problem. What about the others? Sir, we are sitting in the same place, sir. In the same place, the same network is there. No, you are sitting in your different places. Dorcas, from where you? Sir, I'm in Zanzibar now.
No questions, Prof.
Pardon?
I have no question.
You don't have any question? What about Macman Lemma?
I have no questions, Prof.
See, it will stop at any time.
Mungu